This is Dr. David Shine, and welcome to Business Law 101. The older version of shared responsibility was contributory negligence. And it used to be if the plaintiff had any significant part of being hurt, then they could not recover. Here's a good example. An adult is riding their bicycle in the middle of the night, no lights, no reflector, and you're driving home from a night at the restaurant, the bars, and you hit the person and they're hurt badly. The question comes up is, well, the bicycle didn't have a light, it didn't have a reflector. How much of that person's negligence is attributable to the bicyclist and not to you as the driver? So under contributory negligence, if you can show that this person got hit because you couldn't see them, the person might get nothing under the older concept of contributory negligence. These days, we've moved to a doctrine of comparative fault. So a jury might find that the bicyclist, because of no light and no reflector, was 30% liable, but you are still 70% liable. So if the damages are $100,000, you might be held responsible for paying $70,000 of damage to the plaintiff. So a comparative fault is pretty much the standard today. And a third concept on this slide is assumption of the risk. Many of you, if you've done anything that's considered relatively risky, zip lining, hang gliding, some of these things, skydiving, you will probably have signed a set of legal documents that say you are assuming the risk because this is a more dangerous activity than normal. Usually if you're playing mini golf with your kids down the street, you probably won't have to sign an assumption of the risk to do the mini golf. Now, one of the most interesting aspects of assumption of the risk is many of us Texans go snow skiing in Colorado. Not a lot of snow skiing in Texas. And Colorado has an extremely protective state statute that basically says everybody who goes skiing in Colorado has assumed the risk of all injuries. So the resorts in Colorado are completely off the hook. So even if you are out there skiing and the chairlift breaks and you fall, 30 or 40 feet to the ground and break a couple legs or an arm or something, then the resort is not responsible. So assumption of the risk varies in flavors depending on where you are, but it's an important doctrine to be aware of because it bars recovery in many cases. And we talked about comparative fault a few slides ago. So, in terms of the way of dividing the damages. And then, of course, the manufacturing needs to be done at the state of the art, and that can be a very difficult call because if you made something 10 years ago, how can you be responsible for the fact that there have been significant improvements since then?